obligations, the acquisition of rights, as well as the extinguishment or loss of those already acquired, shall depend upon the happening of the event which constitutes a condition. So this is already the what we call as suspensive conditions, in which suspensive conditions, the happening of which will give rise to the acquisition of right. If the suspensive condition is fulfilled, then the obligation arises. The acquisition of rights, as well as the extinguishment or loss of those already acquired, depends upon the happening of the event. Conditions, this is also known as the conditions precedent or conditions and antecedent. Be it noted that what characterizes an obligation with a suspensive condition is the fact that its efficacy or obligatory force is subordinated to the happening or of a future and uncertain event. So this is the happening of a future and uncertain event, for short, condition. The acquisition of rights, the existence of obligations, as well as the extinguishment or loss of those acquired, depends a happening of the future and uncertain event. Example: I promise to do what you ask. I promise to do what you ask, provided that X condition is first complied with. So the condition here is X must comply with the first. X must comply first with the condition. Then that's the time there will be what you ask. I promise to do. So there is a performance already. When ask performs the condition, then there will be a performance on the other side. Another example in which A in his will gave some property to B, provided that he would die within a certain period. A did not die during the said period. So since the suspensive condition was not complied with, B is not entitled to inherit. So when the condition, if suspensive condition is not fulfilled, the party would stand as if the condition never existed. Since the suspensive condition was not complied with B, B is not entitled to inherit. That is from the case of Natividad versus Gavino. If in a judgment by a court, it is stated that unless a ban is given, unless a ban is given, the judgment can be enforced even while it is still on appeal. The giving of the ban should be considered as partaking of the nature of a suspensive condition. If the ban be not given, enforcement or execution can issue. Again, in a judgment by a court, it is stated that unless a ban is given, the judgment can be enforced even while it is still on appeal. Diba? There must be a ban. Otherwise, judgment can be enforced even while it is still appeal. The giving of the ban should be considered as partaking of the nature of a suspensive condition. Yes, the giving of a ban is considered as a suspensive condition. Otherwise, if there is no ban, judgment shall be enforced. If the ban be not given, enforcement or execution can issue. So in a case of San Miguel versus Albinias, before the writ of preliminary injunction can be granted, before a preliminary writ of injunction can be granted, the posting of ban to answer for consequent damages is condition sine qua non, indispensable suspensive condition or condition precedent. This is a condition precedent wherein the posting of ban prior to the execution of writ of preliminary injunction, prior to the granting of the preliminary injunction. Diba? Before the writ of preliminary injunction be granted, the posting ban to answer for consequent damage shall be posted. Next, so this time let's go with resolutory conditions. As a review, in which suspensive condition, in which the acquisition of rights in condition obligation, the acquisition of right or the extinguishment or loss of those already acquired depends upon the future and uncertain event. Then um, it is a suspensive condition. Again, if suspensive condition is fulfilled, the obligation arises. So if the suspensive condition did not fulfilled, so therefore um, the parties would stand as if the condition or obligation never existed. Resolutory conditions. If if suspensive condition is a condition precedent or condition antecedent, the resolutory condition it's a condition subsequent. Here, rights already acquired are lost once the condition is fulfilled. There is already acquired right, diba? It's the opposite of suspensive condition. In suspensive condition, there will be a fulfillment of condition first, and that's the time the acquisition of right and obligations. But here in resolutory condition, there is already a right. There is already a right, but upon the fulfillment of resolutory condition, fulfillment of the resolutory condition, there is an extinguishment of obligation or right. Here, rights are already acquired. Rights already acquired are lost once the condition is fulfilled. That is in resolutory condition. Example, I will give you my car now. I will give you my car now, but should you pass the bar, the donation will not be effective. If you pass the bar, you must return the car to me. So here, you have already the car. You have already the car. But if you will pass the bar, the donation shall be ineffective and there must be a return of the donated car. This is the opposite in resolutory condition, suspensive condition. Another example, Parks versus Province of Tarlac, 49 Philippines 142. Concepcion Searer and James Hill donated land to the province of Tarlac. They donated land to the province of Tarlac on condition that the latter, the province of Tarlac, would build upon the land a schoolhouse and a park. So that's the condition. The work to begin within 6 months from the date the parties ratified the donation. The province accepted the donation, and the land was registered in the name of the donee. Several years later, noticing that the province had not performed the conditions, the donors sold the land to Mr. Parks. Now Parks sued to recover the land from the province. So again, in this case, Concepcion Series and James Hill donated a land to the province of Tarlac on the condition that province of Tarlac will begin within 6 months, will build a schoolhouse in a park. But the province failed to perform within the said period. So therefore, the donors sold the property or sold the land to Mr. Park, and now Mr. Park is filed an action for recovery against province of Tarlac. So what's the Supreme Court rule? Or what's the ruling of the Supreme Court? Parks has no right to get the land. It is true that the donation was revocable, yes, because of breach of the conditions. But until the donation was revoked, it remained valid. So in this case, there was no revocation of donation. There was an immediate selling of the land to Mr. Park. Searer and Hill had no right to sell the land to Parks. One cannot give what he does not have. Nemo that code non-habet. So it means to say, in this situation, Concepcion Cyril and James Hill are not anymore in possession of the land because there was a valid donation to the province of Tarlac. Then therefore, they don't have any more the possession. They do not have any more the ownership over the land. So it is already the province of Tarlac is the owner of the land. The donors cannot anymore sell what has been donated, diba? Because they will become they are not anymore the owners and they cannot sell what they do not own. Nemo that code non-habet. What the donors should have done first was to have the donation annulled. Yes, that's the best remedy. Again, one cannot give what he does not have. One cannot give what he does not have. This is in contract of sale. Nemo that code non-habet. The remedy of the donors is to make the donation and be annulled. And after that was done, they could validly have disposed the land in favor of parts. Now, let's go to conditional perfection of a contract. Conditional perfection of a contract. What's that? If the perfection of a contract, if the perfection of a contract depends upon the fulfillment of a condition, conditional perfection of a contract. The perfection of a contract depends upon a condition, depends upon the fulfillment of a condition. Non-fulfillment thereof means the non-perfection of the contract, since the suspensive condition should have been first fulfilled. This is from the case of Ruperto versus Cosca. So, this is valid in which if the perfection of the contract depends upon the fulfillment of the condition, is valid. Non-fulfillment of that means non-perfection of the contract, since suspensive condition should have been first fulfilled. So these are some cases and doctrines. Panganiban versus Batangas Trans Corporation, in which the Batangas Transportation Company bound itself to furnish a certain number of trucks provided they were available on that needed day. On said day, no truck was available. Again, Batangas Transportation Company bound itself to furnish a certain number of trucks. Yes, provided they were able on the day needed. Yes. But on that day, there are no available trucks. So the issue now here, was the company bound still to supply the trucks? The court ruling is the company never incurred the obligation since the condition did not materialize. So that is non-fulfillment. Non-fulfillment. So therefore, non-fulfillment of the condition, the non-fulfillment of the condition, the party would stand as if the obligation or condition never existed. Article 1182. When the fulfillment of the condition depends upon the soul of the debtor, so this is now the potestative condition, potestative obligation, wherein the fulfillment of the condition depends upon the sole will of the debtor. The conditional obligation shall be void. So again, when the fulfillment of when the fulfillment of the condition, when the fulfillment of the condition depends upon the will of the debtor, the conditional obligation is void because um it should be the debtor or it should be mutual between the creditor and the debtor for the agreement of the conditions. Since if it depends upon a chance or upon the will of a third person, casual, this is a casual obligation in which if the condition depends upon by a chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of this code. So, there are three kinds of conditions: potestative, casual, and mixed conditions, diba? When the fulfillment of the condition depends upon the will of the debtor, depends upon the sole will or exclusive will, depends upon the exclusive will, or depends upon the sole will of the debtor, the condition of the obligation is void. But if but when the fulfillment of the condition depends upon the will of the creditor, when the fulfillment of the condition depends upon the will of the creditor, then the conditional obligation is valid. But the opposite, if the fulfillment of the condition depends upon the sole will or exclusive will of the debtor, the conditional obligation is void. Potestative is also known as facultative condition. Casual depends on chance or by the will of a third person. Potestative or facultative condition, di ba? Again, potestative if the fulfillment of the condition, but what's I call potestative condition? It's a condition depends upon it is the fulfillment of the condition of a condition depending upon the will of one party, depending upon the sole will of one party. That is potestative or facultative. If it is on the part of the debtor, fulfillment depends upon the sole will of the debtor, that's void. Example, I'll give you 1 million pesos. Next month, I will pay it. Or next month, if I leave, no, I'll give you 1 million pesos next month if I leave. So therefore, that's depending upon the will of the creditor. But when it comes to resolutory, if potestative, if potestative is a suspensive condition, if a potestative condition is a suspensive condition, that is void, di ba? Even the creditor or the debtor. Example, on the part of the debtor, I will pay um, I will pay the debt as my means permit me to do so. That is potestative on the part of the debtor. That is void. Even on the part of the creditor, also void. I'll give you 1 million pesos next month if I leave. That's void also. Take note, when it comes to potestative condition, in suspensive condition, um, void either on the part of the creditor or the debtor. But potestative condition in a resolutory condition. Example, I will employ you now. I will employ you now as my superintendent in the factory. As my superintendent in the factory. I will employ you now as my superintendent in the factory. But it is understood that if for any reason, including my own cancellation of the order, the machinery which I ordered from the United States will not arrive, the employment will end. Diba? Again, I will employ you now. You have already the right of being a superintendent in a factory. Resolutory condition, rights are already granted, there is already acquired rights, but the fulfillment of the resolutory condition extinguishes the obligation. So here, I will employ you as my superintendent in the factory. But it is understood that for any reason, including my own cancellation of the order of the machinery which I ordered from the United States will not arrive, the employment will end. So if the ordered machinery from the United States did not arrive, so therefore your employment being a superintendent will be extinguished or will be canceled. Diba? Again, for resolutory condition, potestative condition on resolutory condition, in which resolutory condition, it depends upon the will of the creditor. So the employer said that you will be a superintendent in the factory, but if there is non-arrival of the machine I ordered from United States, your appointment will be cancelled. This is from the case of Taylor versus Yu Tieng. The court ruled that a condition, both potestative and resolutory condition, may validly even if the condition is made upon the will of the obligor. Here, for for the resolutory potestative condition with resolutory condition is still valid. This is from Taylor versus Yutian. But when it comes to resolutory, but when it comes to suspend potestative condition with suspensive condition, it's void on the part of the debtor or creditor. But potestative condition with resolutory condition in Taylor versus Yutian, a condition both potestative, a condition both potestative and resolutory condition may validly even if the condition is made to depend upon the will. A condition both potestative and resolutory may be validly even if the condition is made to depend upon the will of the obligor. Take note, it is submitted that although this is indeed a resolutory condition, because the order would be either cancelled or not, still it has the effect of a resolutory term because the employee here would not be obliged to return wages for work already done. Yes, the employee here will not anymore be returning what the wages because he works for it. Diba? No? Still, it has the effect of resolutory term because the employee here would not be obliged to return wages for work already done. That is already unjust on the part of the employer if he will be asking a reimbursement from his employee for arrival of the machinery, diba? Cancellation of appointment. Potestative on the part of the creditor is valid. I will give you my fountain pen if you desire to have it. Again, potestative. If it is a potestative condition, depends upon the sole will of the creditor is valid. I'll give you my fountain pen if you desire to have it. This is now a question. I'll give you I'll give you 1 million pesos if I can sell my land. I'll give you 1 million pesos if I can sell my land. Suppose I am able to sell my land. Am I bound to give you 1 million pesos? Yeah, the answer is yes. Yes. I will give you 1 million pesos if I can sell my land. That is a suspensive condition. The fulfillment of the suspensive condition gives rise to an obligation. So, the creditor here, one party here sells the land. So, therefore, um, there will be an obligation to give the 1 million to the other. It is submitted, yeah, the answer is yes. While apparently, this is a potestative condition because I may or I may not sell. Diba? But the phrase here, I can sell. Which in a similar case, in Osmeña versus Rama, 14 Phil 1999, which in a similar case, held that such a stipulation is void. Still, it is not purely potestative, as distinguished from the simply potestative, but really a mixed one. Because the selling would depend not only on my desire to sell, but also on the availability and willingness of the buyer in other circumstances such as price, friendship, or the necessity of transferring to a different environment. This is from Hermosa versus Longara, insisting here that it is not a purely potestative, it's a mixed one. Because the selling of the land depends upon not only the desire to sell, but also the availability and the willingness of the buyer to purchase the price. This is another case, Hasinto versus Chuwaleng. A owned a house rented by B. A sold the house to C, and C agreed to pay the balance of the price as soon as B leaves the premises. C was to take care of seeing to it that B vacated the house. C was to take care of seeing to it that B vacated the house. A now says that the contract is void because it is potestative on C's part. Again, in this case, A owned a house rented by B. A sold the house to C, and C agreed to pay the balance of the price as soon as B leaves on the premise. Diba? This is now the condition. C will only pay the balance if B leaves the premises. C was to take care of seeing to it that B vacated the house. Yes, C is very secured. C secured that A would eject B, the tenant, the leasee. A now says that the contract is void because it is a potestative on C's part, di ba? Depending upon the will of C. The court ruled that the contract is valid. Yes, contract is valid. It was not purely potestative on C's part. It's a suspensive condition. It's a suspensive condition on the part of C in which A must vacate, A must eject the tenant B to give rise the obligation on the part of C to pay the balance price. The contract is valid. It was not purely potestative on C's part. Firstly, B might vacate of his own accord in his own will, and C would now have to pay. So the fulfillment really in part depends on the will of the third party. This is a mix. Because if B will vacate, then C will pay the balance. No? Might vacate of his own accord on his own will, and C would now have to pay. So the payment will really part of dependent upon the will of a third party. B is a third party. Secondly, if C did not ask B to leave, A could be very well do so by an action of unlawful detainer against B. And when B ousted, C would have to pay. The condition being mixed, the contract is valid, yes. The contract is being mixed. So again, if there is a tenant, this is a common case when it comes to lease contract. There is non-payment on the part of the leasee. There is no the leasee. There is non-payment or of rent on the part of the leasee. So the remedy of the owner of property is to file an unlawful detainer in the court, or Yes, unlawful detainer of the unlawful detainer. Otherwise, if the owner cause a force, threat, to eject or to oust the tenant or the lessee, it's a grave coercion that is criminal liability under the revised penal code. Grave coercion. The owner forced the lessee or tenant to be ejected. So the proper remedy is to file an unlawful detainer. So in this case, this is a mixed condition wherein if if A can oust but through unlawful detainer B, then C will pay the balance. If B in his own accord will vacate the premise, C will be paying the um, C will be paying the balance. This is a mix, partly depend upon the will and partly depend by a chance. Why depend upon by a chance? Because it depends upon a third person, and the other one it's depend upon the will, or um, it depends upon A, diba? So the next will be Article 1183.